Chinese firm says it has released one of Nigeria's presidential jets in its possession to allow President Bola Tinubu travel to France for a meeting with President Macron next week. A court in Paris had granted the firm permission to seize 3 Nigerian presidential jets over an alleged $74.5 million debt awarded to it against Nigeria. In the meantime, Nigeria's Foreign Affairs Minister Yusuf Tuga has warned against sub-national governments entering international agreements without recourse to the federal government. He stressed that such agreements often lead to diplomatic challenges. The minister confirmed ongoing diplomatic talks and legal actions to resolve the issue.
The Attorney General and I are working on it, both diplomatically and then from the legal perspective as well, to ensure that this issue is resolved. But you see, again, this is part of the problem when subnational actors like state governments take it upon themselves to go into agreements, go into international arrangements without recourse to the Ministry of Foreign Affairs, without recourse to the federal government, and then when it goes awry, we are left with the problem to deal with. And that is why it's always important that such arrangements should be registered with the mission there, with the embassy, with the Ministry of Foreign Affairs, and with the federal government. This is something that Ogun State, under a different administration, not this governor, entered into that we're not aware of. All we know is that, you know, they're going after Nigerian assets. That's why really foreign or international negotiations is not the purview of subnational actors. You should always have those that are experienced in such an area, that have the necessary skills and the necessary training to negotiate these sort of agreements.
Well, Yusuf triggered there, but we'll make more sense of what he said so far by bringing in Arise news analyst and lawyer, Dr. Sam Amadi, for more on these stories. Good to see you, and thanks for your time. Trying to look at this and looking at, we understand that sovereign immunity, which is under international law, state-owned property like presidential jet, is generally immune from seizure or attachment in foreign jurisdictions. Before you jump into that, let's start off by what Tuget said. First, he's making some form of clarification there. He says this deal wasn't between the Chinese firm and the federal government, but between Ogun State and the Chinese company.
Well, under international law, the federal government represents states, so the states transact to the federal government. But that's not the point. The point is that when this transaction started, the federal government itself took actions. It wasn't like Ogun State went to China. And first, there was an investment treaty between Nigeria and China. We spelled out clearly the terms that protection for no unfair treatment, equal unfair treatment, no expropriation, and all those. And then the investment had a third-party benefits in terms of companies. So it was done in anticipation of that. And then when this free zone started, the federal government supported. The federal government also gave tax waivers through the export processing zone. So it wasn't like this was Ogun State. No, this had federal government backup as part of its sovereign support for states in business. And so it's not actually correct to say, and by the way, this was also litigated. The federal government also had to arrest, detain some of the executives of this company, and then they went to court sometime in 2018 to 2021, I think they got a judgment. Nigeria contested it in that arbitrary decision and back to court, and then they went to the US, and the New York court clearly articulated, based on the Foreign Sovereign Arbitration Act of the US, Immunity Act, and based on the New York Convention, it's a multilateral convention, it's carefully looked at. Nigeria had, it was a matter that they could grant, enter final judgment and then execution. So that's, and on the issue of sovereign, the immunity under the Vienna Convention, deals with first with immunity from arrest, detention of embassies and the diplomats, their homes are free from search and detention. It's arguable whether a presidential jet, so said, I mean, Air Force, whatever, Nigeria Air Force, is necessarily, if the president is not there, has that immunity. There's also immunity personnel. You can't arrest diplomats, even when they commit some crime. We've seen cases in the UK, shooting and all that. So those three dimensions, of course, jurisdiction, immunity from jurisdiction, civil, criminal prosecution. It's not very clear, really, that you can't attach vessels that belong to state. It's also arguable that you may say, well, since it's a presidential jet and the president is a sovereign and his embassies are immune, one can argue that perhaps vessels and aircrafts belonging to the federal government is immune, but not really well established. And then, so I would argue that this is a case that was contested by Nigeria. And again, maybe it builds to three things. How we make these contracts, and also how we litigate. So maybe some negligence along the chain of litigating from you agree to arbitrary award, and it's entered against you, $55-something million.
Well, let's quickly jump on this because we're looking at time, and the sanctioning of justice is, judges rather, by the National Judicial Council. Speak to us on how this is going to pan out, especially now. This is one big task that the CJN will carry out before he bows out.
I think it's a routine that many petitions, the NJC decides based on evidence what to take on. They really challenge two fronts. One is that people think that the Chief Justice of Nigeria's superintendent, the composition of the NJC usually tilts towards judicial officers and some kind of collegiality. So some people have argued maybe we should be much more accountable by broadening it so that it's not about self-policing. So the other issue is also around whether they need to be more transparent and public. They try to advertise what the issues are. Maybe there should be some real-life proceeding, so that not just tell us this person convicted, but also we have evidence, we can read through the transcript and see what they said, so that will help to restore confidence in the judicial, because some people might think that those who are unfortunate get indicted and punished, but some who ought to be indicted are still on the bench. But so far so good. That process can work better. Look at composition, look at procedure, and look at process, so that maybe more transparency and a much more non-judicial membership that can also help to destroy that kind of judicial cult, if you like.
Well, Dr. Sam Amadi, many thanks for simplifying things for us here on these two burning issues, which you can actually play catch up on our website, arise.tv.